This committee meeting is called back to order. I'd ask the witnesses who are remote to open up your video line. And we will now begin with questions, and I will proceed under the 5-minute rule. And I recognize myself for 5 minutes. During the period the journal analyzed, 1 in 5 federal judges who disclosed holdings of any individual stocks unlawfully heard at least one case involving the companies whose shares that they owned. 20%. Mr. Hedler-Gaudet, do those statistics surprise you? And if so, why do you think that the issue is so prevalent?
Thank you, Chairman Johnson. Those statistics do not surprise me, and they should not surprise anyone who has been watching and observing the federal courts for any length of time. I mentioned in my oral testimony that the federal judiciary is the least transparent branch of government, and it is not surprising that with that lack of transparency, we see violations of laws and protocols and rules. We've seen these kinds of reports before, too. There was recently an article in the North Carolina Law Review that raised up some of these same issues and pointed to similar statistics. In 2014, the Center for Public Integrity did a very good investigative deep dive into this exact issue, and they found that 26 more judges had ruled on cases that they had a financial conflict of interest in. So this is a long-standing and persistent issue, and I think it really, speaks to the need to pursue reforms that would enhance and strengthen the integrity and the legitimacy of the courts. And the way you do that is by ensuring that the public has faith and trust in the impartiality of federal judges. And I think that faith and trust is fundamentally compromised and undermined as we see these reports continuously cropping up.
Thank you. Professor Jefferson, what other lessons should we draw from the fact that such a significant proportion of judges failed to abide by a clear statutory mandate to recuse themselves?
Well, I'll pick up on the previous comments and say that this is a long-standing problem. As I noted earlier, I don't think we want to be in a world where we rely on journalists to enforce judicial ethics, but that's what's happened here, although, again, I think we need to welcome these kinds of investigations, and I commend the reporting. But that North Carolina Law Review study that was published in 2020, it documented, I believe, 200 instances that were similar where judges were hearing cases when they owned stock in parties. There's a law review article I also cite in my written testimony that goes back to 2015, published in the Georgetown Journal of Legal Ethics, dealing with these issues too. And so they've been with us for a long time. Let me just point out one anecdote, though, that I think goes to my overarching theme, which is that we need to shift from a culture of silence to a culture of compliance. It was significant to me not only that the North Carolina Law Review published this information, but when the scholars thanked the research assistants who worked on it, one of those research assistants asked to be unnamed for fear of upsetting a judge. And I think we want a world where our judiciary welcomes it being brought to their attention if they're out of compliance with their ethics rules, so that we can sanction and penalize our judges, but so we can work together to make sure they are complying with all of their ethical obligations. And it's the concern about the intimidation for fear of upsetting a judge that has perpetuated in part the very problem that we're here today confronting.
Thank you. When the journal reporters informed these judges of their violations, many relied on a variety of excuses, that they were unaware of the trades, that the recusal list had misspellings that were missed by the judiciary's conflict screening software, that their trades resulted in losses, or that they had a hands-off role in trading. I'm worried about what these judges' excuses reflect about the culture in the judiciary. Professor Jefferson and well, you won't have time to answer within the 5 minutes, so I'll just limit it to Professor Jefferson. Do you think that judges see these kinds of failures as harmless or just simply being no big deal?
I wouldn't want to presume to be in the mind of any of the judges and how they were responding. I can only take them at face value, what they said in response to the reporters. And you've read the reporting as well. Some of them, it seemed, were not taking it seriously and did not think that it mattered or that the rule applied to them. I think that there are a few different tensions here. One is the fact that the American Bar Association's model code for judges has a different standard, and so perhaps some mistakenly thought the more liberal standard applied to them. But the reality is when Congress implemented 28 U.S.C. Section 455, that bright line prohibition, it was very clear what was intended, not only that judges not hear cases where they hold stock in parties or have a financial interest, no matter how small, but also Congress, in the legislative history, it reflects that they intended to have a higher standard than what the ABA had suggested in its model code. So it is incumbent on our federal judges to be aware of all of the rules that apply to them. And my hope is that through this hearing, through reporting like what we've seen, that we will be seeing a shift in the culture.
Thank you. My time has expired. I will next turn to Mr. Bishop for 5 minutes.
Thank you, Mr. Chairman. Professor Jefferson, I generally agree with the notions or the recommendations and the thoughts you've laid forth in your testimony, in particular the notion of a culture of compliance. I do have some, as someone who practiced law for a long time, I didn't encounter judges that I thought were making decisions based on their financial interest. And this disclosure requirement or disclose anything or to deal with any financial interest, no matter how small, I think what happens, we end up giving the judiciary a black eye in a way because it's almost an administrative task that doesn't really belie any interest, and they're just not aware of it. And so it ends up looking like there's this massive non-compliance, which is unfortunate. But I also get why, and your article made clear why there needs to be, why a per se, however small rule is out there. One question I had is, I noticed that one of the things that's talked about in reform is whether or not to disclose publish all this information the same way my financial disclosure statement is published on a website. Can you offer any insight why that was not done when this scheme was originally set up of judges having to disclose internally or make the reports, but somebody's got to ask for them, like you said?
I don't have particular knowledge about the thinking behind the process for disclosures that was adopted for the federal judiciary as compares to what you're required to do as a member of Congress, other than to note that the federal judiciary is not included in the same law that requires you to disclose in the way that you do. And if I may, I do agree that this bright line rule will inevitably perhaps trip up someone who would have, as I said in my opening remarks, no actual bias in a case, but sometimes that's a trade-off we have to make in order to have these clear-cut rules for eliminating the perception of bias.
That makes some sense. But one of the things you advocate is that there be complete disclosure, publication of this, right? That they be published on a website, somebody could download it anonymously and learn what the information is.
Yes, so I do believe that publicly available information, in particular about recusals, that's my focus. So now in terms of the...
How about the financial holdings?
Yeah, in terms of the financial holdings, there may very well be reasons to limit the disclosure of that, but certainly not beyond the litigants and making it very easily available and readily available. Another one of the big issues for litigants is because the federal judiciary now only files annually, you can have a case proceed for a whole year before someone will even know that the judge that they've been before had an interest, and that's if, of course, it's a judge who is actually disclosing as they should be.
Yeah. Okay, we'll talk. I want to shift gears a little bit. Actually, I said in my experience, I didn't see judges that I thought were doing things for financial interest. On the other hand, my experience and observation has been that the most extravagant expressions of bias have been partisan bias on the part of the bench. And I was just looking as we were sitting here, The Hill did a poll or reported a poll in 2018 that 66% of registered voters think that federal judges were influenced by politics or that their rulings were based more and more on their political interests. Has there ever been any scholarship on the subject of whether judges, federal judges, are affected by ideology and whether that creates biases that they're not properly responding to?
So I think it's, well, recusal can apply beyond financial interests, to be sure. And we should be concerned and thinking about any time a judge has an interest that hasn't been disclosed that is going to either actually prejudice the litigants before the judge or create the impression of bias. And so that can be financial interest. It can also be relationship-based. And in terms of partisanship, I read the same reports that the public absolutely believes that judges are driven by partisanship. You'd think the federal judiciary would be somewhat immune from that, since federal judges are appointed and not elected, as many of our state judges are. But I don't have to tell this committee that politics surrounds appointments just as much as it also surrounds elections. And I think, you know, in terms of a difference, if we want to distinguish between these things, here, at least in this instance, we have individuals before judges, and they have no idea that the judge has a financial interest in perhaps their opponent. So the information hasn't even been disclosed. If a judge is perceived as having a particular political viewpoint, that is often or maybe more well-known. So that's one, I think, significant difference between what we're talking about here with respect to financial interests.
At least it's not concealed, is what you're suggesting.
Exactly, yeah, and sunlight is the best disinfectant, right?
My time's expired. Thank you, ma'am.
We will now proceed to the gentleman from New York for 5 minutes. Mr. Nadler.
Well, thank you very much. Professor Jefferson, while judges owning individual stocks pose a problem under the Ethics in Government Act in Section 455, obviously, judges are permitted to own mutual or index funds without having to recuse themselves. That approach would seem to avoid any public perception of impropriety because the public would rightfully not be concerned when judges do not know the companies in which they own stock. Why shouldn't federal judges be limited to owning just mutual or index funds?
I actually wouldn't disagree with that. I mean, that certainly would be one approach to handle this. Just as one approach is to prohibit owning a stock in a party that's in front of the judge deciding a matter, another approach would be to require all judges, when they come to the bench, to divest of individual holdings and to hold mutual funds or the like.
I would think that would be a superior route because it's proven impossible, despite the Stock Act and various other acts that we have passed, to enforce the law, whereas requiring judges to own mutual or index funds, to put everything into mutual index funds, would be self-enforcing.
Yes, and I'm certainly not a financial advisor, but I'm told that having mutual funds is still a wise investment. And so, you know, in terms of financial concerns that a judge might have that would dissuade someone who's well qualified from the bench from taking on that role, that would be an effective option.
Thank you. Mr. Hedler-Gaudet, this is Chairman Nadler. I'd like to pose a question to you. First of all, what do you think of the idea that we were just talking about of requiring the judges put everything into a mutual or index fund?
Thank you, Chairman Nadler. I think that would certainly be the cleanest way to address this issue. Although as a reasonable intermediate first step, I think doing something like applying the Stock Act and requiring online posting of all financial disclosures of federal judges is a perfectly reasonable way to go.
Can you tell me whether the Wall Street Journal's reporting is the first time we've heard about judges failing to abide by the law governing recusals and ethics and financial disclosure? And further, now that we have this reporting, is there any question that there are systemic problems that Congress and the Judiciary need to address?
I'm sorry, can you repeat the question, Chairman?
Can you tell me whether the journal reporting is the first time we've heard about judges failing to abide by the laws governing recusal, ethics, and financial disclosure? And further, now that we have this reporting, is there any question that there are systemic problems that Congress and the Judiciary need to address?
No, that was not the first time I had heard, or we in the public had heard about those kinds of issues, and I think it absolutely points to a systemic, widespread, pervasive issue. We often say that opacity plays midwife to impunity in the good government community, and I think there's no there's no clearer emblem of that mantra than what happens in the federal judiciary right now.
Thank you very much. Professor Green, first of all, would you comment on the idea of requiring all federal judges to put any stocks they own into mutual or index funds?
So I don't have any specific comment on that proposal. All I would say is that if the concern is about being influenced by one's particular holdings, that might be a solution. But if the concern is that a holding might move markets in some way or something along those lines, it might be an incomplete solution. But this isn't something that I have a deep opinion about.
Mm-hmm. And does the fact that the journal's reporting comes during an era of declining trust in our institutions add urgency to the need to address these problems?
Yes, absolutely. There's certainly, I think, a serious problem of the perceived legitimacy of the courts, and this kind of reporting certainly doesn't help.
And given this context, what risks do we incur if Congress and the judiciary do not address the issues highlighted by the journal's reporting?
Well, the risk is continuing decline in the perceived legitimacy of the courts, which I think are affected by lots of things beyond individual financial issues like what was reported in the journal. But this just adds to the problem.
Thank you. And one issue that the journal's reporting was unable to determine was whether these judges' rulings were influenced by their own financial stakes in the case. But even so, these episodes obviously are problematic. Professor Jefferson, how would you respond to someone who said that because there was no evidence that a judge made a ruling in order to boost the value of his or her stock or sold stock before making a ruling that hurt the value of theirs, the misconduct unearthed by the journal actually is not particularly concerning?
So I guess I have two comments to that. First, even if a judge is not actually biased in a particular proceeding, the appearance of it, there's a harm to those individual litigants because they may not trust in the fairness of it, and then there's also a public perception harm in the legitimacy of the court. But related to this, I would also say that in thinking about the perceived harm, it's bigger than the public perception and the individual harm to the litigants, in that we have a law on the books that federal judges have not complied with. So if we don't think they should have to comply with this law because this law actually doesn't do anything about addressing either the actual harm to litigants or the appearance of harm to litigants because of their bias, then we should not have this law on the books. In the meantime, when it's there, we all should follow our laws until they are changed or are appropriately challenged in our court system, right? But if anyone should be following the law, I would think that the public would expect our judges to be following the law.
Thank you very much. My time has expired and I yield back.
The gentleman from California, Mr. Issa, is now recognized for 5 minutes.
Thank you, Mr. Chairman. My first question is for all. Is there any of our four panelists that believe that judges, federal judges, should be above the law, as was alluded to by Ms. Jefferson? Hearing none, we'll assume that judges should, in fact, obey every law that they know to exist, and they should know to exist better than the average person in society. The second one, there was a lot of discussion in the openings, in the testimony of the constitutional question. And so I'll start with Ms. Jefferson. Our statutes that have to do with disclosure and recusal, do those exist for purposes of regulating the judges, or do those exist for protection of the individual's right to an impartial arbitrator? Which is the actual right that is being protected?
Yeah, so we're protecting the individual's right to due process and to a neutral decision maker. And in terms of constitutional concerns about judicial independence or interference between one branch and another, the Constitution, I think, is very, very clear that it's within Congress's ambit to make the kinds of reforms that I've been proposing here.
So following up on that, if what we're doing is protecting the individual, you've been saying, as have others, about the litigants. when it comes to the Supreme Court, when it comes to the appellate courts, and when it comes to the standard under which appellate courts second guess a federal judge in the original ruling, isn't it fair to say that, in fact, everyone who might be affected by a precedent is, in fact, a person of standing? And I say that because you alluded to the idea that, well, maybe only the litigants would know, but if the Ninth Circuit makes a decision based on a case, it's going to be binding. I don't even get my day in court when I go before a judge who might, in fact, come to a very different conclusion or steer a jury toward coming a different conclusion. So isn't there a broader right than just the litigant or the defendant?
Well, certainly in terms of wanting to ensure that the process is fair, right? So if the individual litigants are impacted by a judge's bias, you are absolutely right that the outcome, that decision, the decision that then governs all of us who are subject to it as precedent, is not legitimate because it's a product of bias.
And I guess lastly, one of my great questions is, and I'm going to piggyback the full committee chairman, I personally don't see any reason, even though I only have mutual funds and don't maintain individual stocks for the reason of conflict, I don't see a reason that we would effectively stop the lower courts. But I'd like you to opine, and I'll start with Mr. Morgan, opine on the question of the Supreme Court, because ultimately those 9 men and women, without a recusal, the decisions are magnificently dependent, and we have, in my time here, 20 years in Congress, we have justices who clearly had a background and a bias because of previous activities on a related case who chose not to recuse themselves. So do you feel that we have the right to demand recusal or a structure for a recusal?
Yes, Mr. Rice, I do. I think that it remains to be seen whether Supreme Court will agree and what they will do. But I think that the ideal solution is for the Supreme Court to voluntarily accept what is already statutory requirement about adherence to the to 455 and that they voluntarily would agree to submit to the Code of Conduct for United States judges, and whether additional obligations would be constitutional. I recognize Professor Green as the real expert on the panel on that question.
Well, and then I'll go to Professor Green and ask the one final question, which is, if we withhold funding until or unless the Supreme Court returns with a standard to their liking, is that constitutional?
I have to think maybe think more than I have right now about the constitutionality of that kind of threat. But as I sit here today,
by the way, that's funding of the court, not funding of their salaries.
Right. So their compensation can't be diminished, but the Congress has quite a lot of control over the funding of the court. And assuming it went through proper legislative channels and was not outside the legislative process in some way, I don't, as I sit here today, see a constitutional issue with that.
Thank you, Mr. Chairman. Yield back.
Thank you. We will now turn to the gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Mr. Chair, and I yield my time to you for whoever you want to yield your time to.
The gentleman is kind, and I appreciate it. Recusal is also a problem with the Supreme Court. Justices' decisions whether to recuse or not can be inconsistent. Those decisions often go unpublished, and there is no means of enforcing a failure to recuse. The decision to recuse or not cannot be appealed. Professor Green, you have written about proposals for reforming the Supreme Court. Should changes to the recusal process be included in any considered reforms to that body?
I do think it's important to address the recusal practices of the court. They're currently covered by the federal recusal statute, 28 USC 455, but there are some special considerations with the court. One is that it's at least awkward and maybe constitutionally problematic for lower court judges to make decisions about whether the court should recuse, given that the court is superior in the constitutional hierarchy. And the other issue is that it's very difficult to replace a Supreme Court justice, as there are only 9 of them, and you could lead to an even court. So there are some important considerations, and there maybe have to be some modifications when it comes to how to enforce a recusal statute against the court. But the lack of transparency is a problem, I think, and I agree with Professor Morgan that the standards that apply to other federal court judges should apply in some fashion to the Supreme Court as well.
Thank you, Professor. Is there anything in Article 3 or in Article 1 of the Constitution that would prevent Congress from directing the High Court, the Supreme Court, to bind itself to a code of conduct?
So there's nothing specific within Article 1 or Article 3 that would prevent Congress from doing that. Part of the problem in this area is that Article 3 is not very specific, and it doesn't say very much about what Congress can or can't do. Congress does have power under Article 1, Section 8, the Necessary and Proper Clause, to make the rules that it thinks are necessary and proper for the institutions of government to carry out their powers, and the court is one of them. So there's no specific prohibition. I think you would get some arguments, some sort of general separation of powers arguments about the court needing to be an independent institution, but I don't find them persuasive in this area, given how much Congress can and does regulate the Supreme Court's behavior in other areas.
Thank you, Professor. The Journal reported a large number of trades by judges during cases in which those judges oversaw suits involving those same companies. Many of those trades netted the judges as much as $50,000. Professor Jefferson, why is this such alarming cause for concern?
Well, I think it goes back to the purpose of recusal, which is both for the individual litigants to feel that they have gotten due process, a fair process, and knowing that a judge is making money off holding stock over one of the parties compromises that. And then, of course, the second purpose of recusal is the public perception. And I imagine that anyone in the public hearing this would find that it diminishes how they hold our courts in esteem. So I think it's problematic for both of those reasons.
Thank you, Chairman. Yes, there should absolutely be restrictions, and I think we've touched on a number of those options in this hearing already. One sort of clean way, as we've already discussed, is just prohibiting the ownership of individual stocks by federal judges. There are other options to look at too, of course. As far as consequences, I think it gets a little tricky because we are dealing with a situation where judges have a lifetime appointment. So there are just a few kind of ways to hold them accountable, and one of them, of course, is impeachment. But that's an extreme approach, and I suspect you all are not going to spend a lot of your time in Congress impeaching judges. So I think the short answer to that is I think I don't have a good answer for you on what to do about consequences. So I think we do need to spend a lot more time thinking about what we can do to hold federal judges accountable, because as we spoke to earlier, they ought not be above the law, and they certainly aren't above the law.
Thank you. We will now turn to the gentleman from Texas. Well, let's see. Actually, Mr. Coleman is not here, so.
I'm here. Comert's here.
Mr. Coleman, I didn't. Oh, okay, I did not recognize you.
Uh,
Oh, okay, I got you. All right. Okay, thank you, Mr. Gomet, you are recognized. 5 minutes.
Thank you, Mr. Chairman. Um, Mr. Morgan, you mentioned the 131 judges identified by the Wall Street Journal article that represent, well, it is a minority of 870. It, of course, is quite concerning, but that's probably, probably talking about a set of about 1,000 people that were judges between 2010 and 2018. So it's a little more than 10%. That's still too many. But I was wondering if there was one action that you could take to bridge the gap so that we don't have that many judges who fail to report potential bias. What would that action be that you would recommend?
Mr. Gomer, I think the single most important is, as I suggested earlier, that the clerk's offices around the country screen the cases as they come in before the judge ever sees them, and has access to the technical capability to not send them conflicting cases in the first place. The second aspect would be that the judges, as others have suggested here, be required to report their trades promptly. I think much shorter than the month or 45 days or all that are prescribed in some other statutes, so that they can be very timely in the action.
Yeah. So, and I'm, pardon my not knowing, is there software that a clerk could utilize to make that check quickly? Like entering in the parties and seeing if there's a judge, is there software that can make that determination quickly?
Well, there is software that is currently used by the administrative office that tries to do that, but and I am not an expert in that software, but it seems not to be particularly effective if we have this many cases that get through. So I think you'd have to adapt the wide range of software that is available to law firms who are engaged in a very similar checking operation every time a new client comes to the firm. So what I'm saying is, I think that this is a solvable technical problem, and that if we implement those kinds of changes, we ought to be able to take care of at least the numbers, which are shocking at the moment.
Well, if this software that's being used is what we're going to tweak, I'm not sure I have enough confidence in that. It seems like there needs to be different software that would be utilized. And in view of the problems that Director Mueller and Comey had with software at the FBI, I'm not sure about the federal ability to pick proper software. They can pick software that costs a tremendous amount of money, but we would need something that actually did what we needed done. And I'm not impressed with the federal government's role in doing that. So anyway, Professor Jefferson, are you aware of software that might be more appropriate to use in the federal courts?
I am not a software expert, so I don't have something to recommend. But I would just say that we need something that certainly allows for better accountability, transparency, something that allows for the information to be more readily available to the public and to the litigants on a timely basis and at a low, if actually really no cost at all.
Well, seemed like it was always cost, but Mr. Chairman, I appreciate your indulgence and I yield back my time.
Thank you, sir. We will now turn to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
All right, thank you very much, Chairman Johnson. This has been a very informative hearing with outstanding witnesses. I do appreciate many of the possible solutions to this dilemma, and it is a serious dilemma. It is critically important that the public have confidence in the judges that they may appear before and the judiciary as a whole. And this reporting by the Wall Street Journal is important and has shown that there are some gaps in that system. So I really appreciate you organizing this hearing. With that, I will yield the remainder of my time to Congresswoman Ross.
Thank you very much, Representative Stanton, and thank you, Mr. Chairman, for holding this hearing. The American Constitution was built on the promise of equal justice under the law, and our founders designed a judicial system that strives to administer blind, impartial justice. Every American is entitled to a free and fair trial presided over by a disinterested judge. The court's legitimacy depends on the public confidence of the people that people place in its ability to deliver this type of justice. Any shortcomings in our ethics systems for judges threatens this confidence. And recent reporting by the Wall Street Journal and in the North Carolina Law Review, and I'm a proud graduate of UNC Law School, has made clear the limit of the judiciary's present system of addressing conflicts of interest. We must act now to put checks in place to ensure that both real and perceived financial conflicts are avoided to restore the public's faith in our courts. And we cannot miss this opportunity to further transparency and ethical integrity in the judicial branch. That's why, with my bipartisan colleagues on the Judiciary Committee, I've introduced the Courthouse Ethics and Transparency Act, along with Ranking Member Issa, with the chairman of this subcommittee and Chairman Nadler, among others. Our bill will ensure that judges face the same disclosure requirements as members of the legislative and executive branches. A double standard for the judicial branch is simply unjustified, and the transparency gap must be closed now. When elected officials breach the public's trust, the public has recourse at the ballot box. Article 3 judges, however, are appointed for lifetime terms. Given the tremendous amount of faith bestowed upon them, federal judges must be held to the utmost standards of ethical behavior and transparency. Our bill will also give the public access to judicial financial disclosures in an online searchable database. This will enable ordinary citizens to access these disclosures without impacting the confidentiality protections currently in place for judges' sensitive or private information. These measures are common sense, bipartisan, and necessary immediately. Again, I'm Representative Ross from North Carolina, and Mr. Hedler-Godet, I want to thank you for your testimony. Please tell us the relationship between the judiciary's transparency and its institutional legitimacy.
Thank you, Congresswoman Ross, and I want to thank you again for your leadership in introducing the bill you just spoke about. We at POGO are happy to support it and stand ready to help as it moves forward. As for the relationship between legitimacy and the institutional integrity of the courts, I think it's not an exaggeration to say that without transparency in the courts, you cannot have legitimacy in the courts. As you noted, we do not have the regularized accountability mechanism for the courts, that is election, that we do for you all in this committee room and that we do have for presidents and so on. We don't have those. What that means is that we need more and stronger ways of holding people accountable in the judiciary, and those are usually going to come in the form of transparency requirements and disclosure requirements and things of that nature. So it seems preposterous that under the current system, federal judges don't even have to comply with the standard that you all in this room have to comply with when it comes to disclosing financial information. At the very least, we need to operate on the principle of what's good for the goose is good for the gander here, and we need to get the federal judiciary to at least a place of parity when it comes to transparency. And I would also posit that that's only the first step. We still have a lot of other things that need to be addressed within the judiciary when it comes to impunity, but this is a very reasonable, pragmatic, common sense first step, and I'd strongly encourage everyone in this committee room and everyone in Congress to support it.
Thank you very much, and Mr. Chairman, I yield back.
Thank you. We will now turn to the gentle lady from Minnesota, Ms. Fishback, for 5 minutes.
Thank you very much, Mr. Chair. I appreciate the opportunity. And I just wanted to ask a couple of questions of Professor Morgan. You know, Congresswoman Ross just mentioned her legislation, and I'm a little concerned that, that the tension and the things that are going on between holding the courts accountable and actually the exposure to danger or the public information being released of the judges. And so it's my understanding that there has been some pushback that this may cause issues for safety and whatever the case for the judges and for their families. And so I'm wondering if that has been given any thought and if there's maybe more information that you might have on that issue.
I don't have additional information on that issue, but I share the concern that broad disclosure that is available to anybody anywhere in this country or around the world is not a value that that has no limits. It is something that ought to be taken into account as you formulate what the standard really ought to be.
And I'm just wondering, I don't know if you've had the opportunity to take a look at the legislation that Congresswoman Ross was talking about. Are there any safeguards in that? Or if there haven't been, what kind of safeguards would you suggest? Well,
I have not had a chance to look at the legislation, but I would suggest to you that the Administrative Office of the Courts is a good source to turn to see what they have thought was important in the past in terms of protecting the judges who really are exposed in some cases to genuine danger.
Absolutely, and I appreciate that suggestion. And just maybe just a little bit, based on what you've heard today, because neither of us have had the opportunity to look at the legislation, but do you really think that this will really change, some of these proposals will really change the behavior of the judges, given that I think we've said a couple of times now, yes, these things are in place, but they're just not doing them. And I'm wondering if you really think that this will have an effect, Professor.
It's very hard to predict, of course, what will actually have an effect, but I think something needs to be done. There's no question. And the Wall Street Journal stories in themselves, I suspect, have gone through, have created a response in the judiciary that will cause them to be seriously concerned about making necessary changes. My own view is that this is not a controversial subject or should not be, and that the solutions that you come up with ought to be ones that, from my standpoint, ideally the court would impose on itself, the court system would impose on itself through the judicial conference or some other institution such as that.
Well, thank you very much, Professor. And with that,
would the gentle lady yield if you're finished?
Oh, yes, I would yield to Congressman Issa.
Thank you. Following up on the gentle lady's questions, and I'll stay with Mr. Morgan. The Wall Street Journal got this information through publicly available documents, correctly?
Yes, sir. They had to work at it, apparently. That is, it was not easy to gather the information, but they are publicly available.
So when you look at the proposal that Ms. Ross, the chairman, myself, and others are at least putting out there as a starting point, aren't we really saying that what is already gettable would simply be gettable in an organized and timely fashion?
Well, I'm not certain, Mr. Ice, I accept your representation.
Okay,
I
well,
simply-
instead, let's go to, wouldn't it be reasonable that if something is already available, that it be available in a reasonable and timely fashion, and that would not change the danger quotient here?
I agree with that point, absolutely.
Thank you. Yield back. Thank you, gentlelady.
Thank you. We will now resort to the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, Mr. Chair. First, I want to thank you and the ranking member for holding this hearing. Notwithstanding your comments. As the arbiters of justice in our country, the impartiality of our judiciary should be beyond reproach. Justices in the Supreme Court may be the most powerful people in our land because their decisions are not appealable and they've got lifetime appointments. They have control and actions over our bodies, particularly women's bodies, and our actions in so many ways. And yet they're not have any particular ethical standards or restraints, not bound by an ethical code of conduct. And that just seems wrong. The whole idea of giving judges at all levels lifetime appointments is to get them free of any earthly desires that they may fall prey to, and that they could be fair and impartial. But at the same time, because they've got lifetime appointments, I've been hearing we can't really sanction them for violating any rules, which seems like a catch-22 of some nature. Hamilton correctly said the judicial branch has neither the power of the sword nor the purse. Professor Jefferson, what does the judiciary have to do to get parties to abide by any rules that they might set forth? Is there anything we can do to get the Supreme Court to take action?
So Congress can require the Supreme Court to adopt a code of ethics. I think a really important point to make here, though, is so there's been a lot of conversation that we can't sanction the federal judges. But I don't think any of us want to be sanctioning federal judges. What we want is compliance with ethics rules. And so the Supreme Court and the lower courts, the key to compliance is public accountability. And we can predict how the judges will respond because we saw how they responded when each one was called, at least a lot of them responded when they were called up by the Wall Street Journal and it was pointed out that they weren't complying with this law. Many of them followed up with litigants to let them know what happened. Many of them took steps to correct the situation. And so imposing that similar kind of accountability by not just requiring an ethics code, but then showing how it's being complied with. So for example, not just requiring disclosure of one's finances, but maybe requiring disclosure of recusal decisions. If a judge is required to actually explain the basis for recusal, there are several important things that happen. One, there's accountability for that individual judge because he or she has to justify the decision to recuse or not recuse. But critically important, it becomes an education tool. Another judge thinks, oh, in a future case, I saw that a different judge recused. I should probably be recusing too. And also for litigants, same thing.
And that's wonderful, but what if they don't do it? What if they don't comply? What if they don't care? Well, your only penalty is shame.
Yeah, and shame could be powerful. I mean, one of the points that I make in my written testimony, I said in my open
Shame
statement
doesn't exist anymore.
Well, I think that may very well be true, but it would at least get us closer to more judges adhering to the rules if we knew there was a public list of judges who weren't complying. We at least now have more judges.
So what are you going to do? They don't lose their job.
Well, true. I mean,
they don't lose their brokerage account.
Taken to the
So they have
extreme,
shame.
it would have to be impeachment, right? Yeah.
Right. And we've seen how good that is.
I understand.
Yeah. Do you have any, Mr. Hedler, Gaudette, do you have any ideas about what we could do to try to make these, can we take away, give them a financial penalty? Can Congress have a law that says if they don't do it, that they lose X amount of money for each failure to comply?
Thank you. So I think it's a bit beyond my expertise to say whether that would be an appropriate avenue to take, although I would point out, this is something that I also feel passionately about, that Congress does emphatically and unequivocally control the power of the purse. So there are a number of things, with the exception of reducing the salary of a federal judge or a Supreme Court justice, that you all can do if you were willing to more aggressively and assertively use the power of the purse around funding of facilities and that kind of thing.
Professor Green, you're out there somewhere, I guess. Maybe not.
Yes, here.
Oh, I see you. There you go. And the power of the purse. Can we really do that? Can Congress reduce the salary of a judge during their term of office? Isn't there some limitation on our reducing the salaries of judicial officials?
Yes, so Article 3 says that the compensation of Article 3 judges can't be reduced during their time in office. So that would be a limitation.
Yeah.
Although other uses of the power of the purse may not necessarily be limited in the same way. So
Well, take away their
altering the
interns,
staff
take
of
away
the
their
court,
staff.
that sort of. Conceivably, it's never been tested, but and there would be an argument about it that it would be resisted. But there's no clear constitutional prohibition on that, no.
All right, I'm over my time, and I've got other questions I'll just put in writing. But I do want to make this comment. The Wall Street Journal story cited many judges. I don't think I knew hardly any of them except for the Sixth Circuit Judge Julia Gibbons. I do not know, she is of a different political party. I don't know of a judge or a person that I've known who's more respected for her rectitude, for her probity, and the fact that she had, or her husband had, some minimal amount of stock in some company that she may or may not have known about is kind of absurd to think that would have affected her opinion whatsoever. So I say, you know, I understand disclosure and transparency, but I put Judge Gibbons over the Wall Street Journal any day. I yield back.
I will now turn to the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair. I would yield my time to Mr. Issa.
I thank the gentleman for yielding, and I think we've reached a kind of an interesting point in the hearing where we're going to keep probing similar questions in different ways, because I think we really need to know or have your opinions. And so I'll go back to Ms. Jefferson. If I'm summarizing what I keep hearing again and again, we have 130 judges who, if I'm sorry, Mr. Cohen has left, but if in a timely fashion had been made aware, and the public was made aware of these failures under the existing statute, most of them would have acted differently. Is that a fair statement based on what actually happened?
I agree with that, and certainly the responses of many of the judges that were reported by the Wall Street Journal suggested that they were bringing themselves into compliance in real time.
So the case for informing them and the case for making it public is pretty well documented based on the reaction of many of the 130. Is that correct?
Yes.
So I think we've gotten past that. Now, the question of enforcement is an interesting one, and you know, whether someone recuses themselves even faced with that. I only have experience with lawyers who, seeing a client with a large amount of money, saw no conflict with having previously represented me on the other side, and wanted me to waive their recusal. So I know that at least among judges, which I understand is where you get, among lawyers, which I understand is where you get judges from, there is a tendency to be reluctant to recuse. So one of the questions that is not in the bill that is going to be considered at some point is a structure to enforce recusal at each level, including the Supreme Court. Would you opine on whether or not you believe that we should be looking at a structure for third-party recusal, meaning, for example, and I'll just give the extreme one, there are 9 justices of the Supreme Court. If there were a challenge to 2 of them based on some recusal item, should the other 7 stand in judgment of whether or not the recusal, or should it be continue to be left exclusively to the individuals?
So I think that would be one important reform, and you can actually look to how that's worked in practice because we have our laboratory of states. So Texas, where I am a law professor at the University of Houston, the Supreme Court of Texas does exactly that. If one of the justices has some sort of conflict or there's a request for recusal, the other justices weigh in on that and evaluate whether or not, in fact, that justice should recuse. In addition to having, and at the lower courts, it's not all of the district court judges, it's one that reviews for another. So the process needs to be, I think, scaled appropriately depending on whether or not you're talking about the highest court or a lower court. The process needs to still happen in a timely manner. And there are other improvements or reforms that I would suggest in addition to not only having another judge review the recusal, also having the documentation of either why or why not a particular judge recuses is an important signaling mechanism. It's accountability for that judge, but it's also education for all judges and indeed parties going forward in the future, whether or not it's appropriate for them to be seeking recusal.
And following up on that, at the lower court, as a matter of practice, at least in the Southern District of California, there's an informal, I don't want a case, but I don't want to say why, that has historically happened where the chief judge will simply pass on somebody with without a reason periodically. Often it's the complexity of the case, or in some cases, simply case load. Do you think that that is an alternative for recusal that could be a tool for those who did not want to get in the specifics of recusal prior to the assignment of a case?
I think it is, and the important caveat I would put in place is just with any reform, we want to make sure there's not unintended consequences. So you would want some protections in place, for example, to avoid litigants judge shopping, maybe put a limit on the number of recusals, that sort of thing.
Having authored the patent pilot bill some years ago, I'm acutely aware that we want to protect from there being only one judge that something goes through. Lastly, the reforms that I just talked about and the others, if before Congress even acts, if we encourage the court to take action in any of these areas, including even the high court recusal discussion we just had, is it within their power to do it, in your opinion? Maybe you and Mr. Morgan quickly. Is that something that you believe they could do sua sponte?
The court itself?
Yes.
Oh, absolutely. In fact, I wish the federal judiciary had already done it, and maybe they will in light of this hearing and this latest report. We'll see. If not, it falls to you.
Does anyone disagree with their ability to do that of their own accord?
I agree, Mr.
Thank you. I yield back. Thank you, Mr. Chairman.
Thank you. We will now turn to the gentlelady from North Carolina, Ms. Ross, for 5 minutes.
Thank you very much, Mr. Chairman. I just want to share some information with the committee relative to Representative Fischbach's question. I know that many members of the committee have not yet had a chance to see the legislation that we've introduced, but I want you to know that the bill does not impact existing judicial safety and confidentiality rules. Under the Ethics in Government Act, which this bill amends, the immediate and unconditional availability of a judge's disclosure is not required if a finding is made by the judicial conference that revealing personal and sensitive information could endanger that individual or a family member. Further, and what happens far more often in practice, is that discrete details in a judge's disclosure may be redacted in order to protect the individual who filed the report or a family member of that individual. And the Courthouse Ethics and Transparency Act keeps this provision in place. So I'm hoping that that will smooth the road for the bill when it comes back to committee for a markup. Professor Green, first of all, I want to thank you for staying with us. I know you had a previous engagement, and we really appreciate you staying with us for this afternoon because you've shed a lot of light on what our authority is and how we can act consistent with the necessary and proper powers. I'd like to ask you, would a publicly available online database of judicial financial disclosures fit within the historical pattern of promoting transparency and ethics in the courts?
Yes, I don't think there's any question about that. Congress has regulated the ethics of lower federal courts for almost the entire time they've existed going back to the 18th century. And I think this is entirely consistent with that constitutional power.
Thank you very much. And Professor Jefferson, you've talked a lot about changing the culture and how we can change rules that would effectively change the culture. In addition to making changes in the law, do you think it would be good to have regular ethics training for our judges?
Well, absolutely. As a legal ethics professor, of course, I'm an advocate of regular ethics training, although I'm mindful that that alone is not enough. In fact, I think professional responsibility is a required course in all law schools post-Watergate, but we still have lawyers who find themselves, and judges, as it turns out, violating ethics obligations, which is why I think an important education tool, in addition to like a continuing legal education seminar, is the public education and the education to the judges themselves when they have to publicly release information on a regular basis.
And you also have said, and I just want to basically make you repeat what you've said to some of the other folks, including my colleague, Representative Issa. How would the transparency of publicly available and searchable financial disclosures encourage the culture change that you've advocated for?
Well, we've been able to see it in real time, but I think rather than having journalists create that transparency, it would be better served for the judiciary itself to create that transparency. When information becomes publicly available, judges who aren't following the rules, either because they don't know about them or just because they think no one's going to check and see if they are, will come forward and change their behavior. And maybe it won't change everyone, but I think that it absolutely shifts the culture from one of silence, where we just don't talk about it because we don't know or because we think silence connotes respect, into a culture where we're coming alongside, not to sanction, but to actually bring ourselves into compliance with our ethical obligations.
Thank you, and I yield back.
Thank you. I want to thank our distinguished panel of experts for your testimony today and for your time. This concludes the first panel for today's hearing, and we will now transition to the second panel. And while we do that, we will be in recess for 5 minutes.
Good afternoon, Judge Elrod. Could I get a quick audio test?
I will now introduce the witness on our second panel. Judge Jennifer Walker Elrod has served as a circuit judge on the United States Court of Appeals for the Fifth Circuit in Houston, Texas since 2007. She was recently appointed chair of the Judicial Conference Committee on Codes of Conduct, which provides advice on the application of the Code of Conduct for U.S. judges, including financial conflicts and recusals regarding financial disclosures. Prior to joining the federal bench, Judge Elrod was a state trial judge in Texas and worked in private practice. Judge Elrod clerked for the Honorable Sim Lake of the U.S. District Court for the Southern District of Texas and earned her BA from Baylor University and her JD from Harvard Law School. Welcome, Judge Elrod, and thank you for participating in today's hearing. I will repeat my earlier reminder that your written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. Section 1001. Please note that your written statement will be entered into the record in its entirety, and accordingly, I ask that you summarize your testimony in 5 minutes. And to help you stay within that time, there is a timing light on your table, or there's a timing light on the screen. And when that light switches from green to yellow, you will have 1 minute to conclude your testimony. And when the light turns to red, it signals 5 minutes have expired. And with that, Judge, you may begin.
Thank you, Chairman Johnson, Ranking Member Issa, and members of the subcommittee. I appreciate the opportunity to discuss with you the work that the federal judiciary is doing to promote judicial ethics and transparency. My name is Jennifer Walker Elrod, and I serve as a judge on the United States Court of Appeals for the Fifth Circuit. On October 1st, 2021, I became the chair of the Committee of the Codes of Conduct of the Judicial Conference of the United States. Judicial ethics and transparency are fundamental to an independent judiciary, and they're fundamental to the public's trust in the judiciary. Litigants must be confident that they will have a fair and impartial forum to bring their cases. Accordingly, the judiciary takes these matters very seriously and is greatly concerned when lapses occur. My message today is first, the judiciary has strong ethics frameworks in place, including the recusal statutes, the code of conduct canons, and the regulatory policies of the Judicial Conference described in my written statement. Those are powerful tools and resources available to the federal judiciary and to the public to ensure the functioning of an ethical and independent judicial branch. Second, the Committee on Codes of Conduct supports that framework through providing advice and extensive training. I'll speak more about that in a moment. Third, courts are working to review and work with parties to address the specific cases where recusals did not occur. Fourth, the judiciary is already involved in additional training and technology improvements. Particularly, we have begun additional training for all judges focused specifically on conflicts checking. Further, circuit councils, courts throughout the country, and the Committee on Codes of Conduct are all working together to review our systems to identify improvements, best practices, and additional procedures that could eliminate lapses in the future. Fifth, and importantly, transparency is essential to the integrity of the judicial branch and the public's trust in the judiciary. That is one reason why the federal courts have public proceedings, even during this COVID era, and why we issue written opinions. It is also why the Committee on Codes of Conduct publishes its advisory opinions. One of the purposes of the Committee of Codes of Conduct is to help judges work through ethical issues ahead of time so that they don't make mistakes. The committee provides ethics training and advice to federal judges throughout the country. For example, at the request of my chief judge, I have personally provided training to the circuit's judges in my circuit just this month on conflicts issues. We also provide confidential guidance to judges and publish advisory opinions to inform both judges and the public. In addition to training improvements, the Judicial Conference, the Committee on Codes of Conduct, and the circuits are working on technological improvements to help better manage conflicts. Judges already use conflict screening software. Both the individual circuits and the Committee on Codes of Conduct are collecting best practices for using the conflict checking software, and our staff are looking for possible additional improvements. The Eighth Circuit has helped spearhead this effort. Recent media reporting on financial interest conflicts has highlighted gaps that we can address through training and technological improvements. While the number of cases with reported lapses is small compared to the total number of cases that we handle, we must strive to achieve full compliance. As I often tell my law clerks, each case is important and deserves our utmost attention. For litigants, a case may be the most important thing in their life. In fact, it may even be a matter of life and death. Therefore, it is essential that litigants believe the judges who hear their cases will be impartial. The judiciary's goal is full compliance with ethics and reporting requirements. The committee and I will work tirelessly to meet this goal. You have my word. Thank you again for the opportunity to appear before you today. Thank you.
Thank you, Judge. We will now turn to the gentleman from California for 5 minutes, Mr. Issa.
Thank you, Mr. Chairman. And Your Honor, one of the challenges that I think we face here is we hear you, we know that your intentions are good, but I'll use Texas for an example. We had a judge in East Texas who had very obvious conflicts of interest as he handled more patent cases with family interest and family financial benefit for many years, and there was no action taken by the court. We now have a judge in West Texas who has made a cottage industry out of a massive amount of cases, and we're still waiting to see his financial disclosures even filed, or at least made available. Can you tell me how we can get compliance with existing law so that we can have better confidence? And when I say compliance, I mean uniform and complete compliance, because we know that you do well 80% of the time, but of course the interest is in the 20% that we don't see.
Well, you're talking about compliance, two different areas. One is in financial disclosures, which is one bucket, and that's the financial disclosures process is under the jurisdiction of the Committee of Financial Disclosures. And then you're talking about recusal checks, and that's under the committee that I chair now. And it's very important that judges be trained fully on what their recusal obligations are. We learned recently, for example, that judges had some confusion in this regard. The judges thought separately managed accounts, some judges did, not many, but if you have any, that's going to cause a problem. Thought separately managed accounts were the same thing as mutual funds. Well, mutual funds have a safe harbor under our ethics guidance, and separately managed accounts are considered to be controlled funds, which do not have a safe harbor. So we are doing training.
And Your Honor, I appreciate that. I was thinking, for example, if you do not see, if you're not able to review financial disclosures and they're not being produced in a timely fashion, then how do you provide guidance for those who likely should recuse? In other words, today, neither you nor the Financial Disclosure Separate Organization have a timely requirement to consider recusals and the necessary information to, in fact, make a case-by-case decision, meaning you're not in a position to tell somebody, hey, you did have that separately managed but item, and oh, by the way, you should have recused yourself because one, the compliance is limited, but in the reporting, but then secondly, that's not part of, if you will, a case review that you or some other part of the third house does.
Well, with regard to ethics conflicts checking, each judge has to keep a list of his or her recusal interest. And that's not just financial interest, that's other interest as well. And then those have to be shared with the required conflict screening people in their clerk's office so that those can be done electronically. So there is a requirement that those lists be maintained. To the extent, though, I hear you. I think that you have concerns about the financial disclosure reports, which again is a completely different system.
But
And it's
Your
not.
Your Honor, not to
Sorry.
interrupt you, but the time is very limited.
Sure.
Of course, a lot of what we're talking about is financial disclosure, but we're really talking about, since the court has not created an ability to second guess the judges and to have the information and to make sure the information is being delivered in a timely fashion, it's one of those, if you will not act, how can we not feel it necessary to create a series of laws that cause you to react in a way that is more than just hoping that a judge who is perhaps confused, perhaps is misinformed, simply doesn't do that? And I gave you the example first of East Texas, now of West Texas, and I deliberately didn't mention names, but these judges have become notorious for basically where patent cases go. And if they have financial conflicts or prejudices, the fact is they've made no effort to recuse themselves, not once.
Well, Mr. Isa, it would be inappropriate for me to comment on any particular circumstances regarding any particular judges. But I would say that there is a system for disciplining judges that don't comply with our conflicts checking regulations.
And if you'd provide to us a list of any judges that have been disciplined for the record, I would appreciate it. My time's expired, and I don't want to be unfair to the chairman, but if you'd provide us a list of any disciplines so that we can review that and see whether it's proportional.
I can't. Thank you.
When the Journal reporters asked the judges they profiled why they failed to recuse themselves from cases on which they had a clear financial conflict of interest, several of them blamed the judiciary's conflict-checking software. That simply cannot be a valid excuse. Aren't judges responsible for knowing what stock they and their spouses hold and taking the necessary steps to avoid hearing cases that they must recuse themselves from?
Chairman Johnson, judges are responsible for maintaining a list of all their financial holdings and being knowledgeable about their financial holdings, as well as the holdings of their spouse and minor children. So that is the judge's responsibility at all times.
The bottom line is this: if we cannot assume that judges are doing something as basic as checking whether they own stock in a party in a case before them, Congress may need to act. For example, should Congress require that judges affirmatively state that they have checked whether they have to recuse themselves from a case and then impose penalties for non-compliance?
Mr. Chairman, Congress, I know that I can't speak of what Congress is doing, but I can tell you what the courts are doing. We are making sure that the judges know they have these obligations. We're making sure that we don't have gaps in our software and that these checks are performed at the very instant of the case coming to be and then are repeated should the parties change or some person's financial circumstances change. So we are making sure, and as I mentioned before, judges who do not follow these policies, which are policies of the Judicial Conference that all judges check and participate in this, can face discipline from the Judicial Council and the Chief Judge in their circuit.
And so can you commit to providing the committee, pursuant to Congressman Isa's request, a list of actions that the conference has taken with respect to holding judges accountable for failing to recuse, or failing to report?
I cannot commit to providing that list, but I certainly will make an inquiry about that. The problem with that is that judicial conduct matters are confidential while they're ongoing. Sometimes they can give a public reprimand or something upon the conclusion of them, but if a proceeding is ongoing, that is generally considered a confidential proceeding. But we can follow up with the
Well, yeah, just simple numbers.
I'll follow up with the conference on what could be provided.
Thank you. A handful of proactive judges have taken the initiative to post their own recusal lists or versions of that information online in their local courthouse websites. I applaud them on taking those steps and showing that they take their responsibility seriously. Shouldn't every judge simply be required to post recusal lists online?
Well, there's some problems with the requirement to post recusal lists online. First, recusals are not only about finances. One reason for recusals might be personal relationships, or even animosity between parties and the judge or the judge's family. And disclosing such relationships could harm the privacy of third parties. But also, and very importantly, publishing these types of lists could lead to forum shopping. We're all aware of situations where people hire particular lawyers because they think someone's going to be recused or sue a particular party or bring them in. So there are concerns about forum shopping and privacy interest of third parties that would be affected by those types of lists.
Thank you, Judge. We'll now turn to the gentlelady from North Carolina, Ms. Ross, for 5 minutes of questions.
Thank you very much, Mr. Chairman, and thank you, Judge, for being with us and for taking on quite a heavy load dealing with judicial ethics. And so we appreciate both your time with us and your time away from the bench dealing with your fellow judges. We understand that the Judiciary has not made judges' 2019 annual disclosures publicly available in response to a request for all disclosures. Why does it take so long for the information to be available, and could this lag prejudice a litigant who has grounds to request recusal due to a conflict of interest?
Thank you, Congresswoman Ross. First of all, I just want to reiterate that the financial disclosure process is under the jurisdiction of the Committee of Financial Disclosure and is in a totally separate system than the recusal system. One is a transparency measure and one is a recusal judicial ethics measure. But I did want to say that it's my understanding that the reason these reports have taken a long time, and I agree with you that they have taken a long time, is that they undertake a lot of these preparations of these disclosures, that when they get so many thousands of requests for disclosures, and they do a lot of the preparation by hand. However, it's my understanding that the Judiciary in that group, that committee, is developing and implementing a new electronic financial disclosure system, which will include features for filing and features needed for releasing the reports to the public on a more timely basis. Obviously, technology can help the Judiciary in this area. We can do so many more things using technology than by hand painstakingly go through these reports. Obviously, the interests are improving the timeliness of response to requests to review reports, while also taking into account the serious security concerns with the increasing availability of personal and sensitive information available about judges online. But I do believe that the Judiciary is in the process of automating this process with the goal of improving the timeliness. Thank you. I can't hear you.
I'm so sorry. To my second question, could the lag prejudice a litigant who has grounds to request recusal due to a conflict of interest?
I'm not familiar with the process of using financial disclosures for recusals in cases. I would hope that that the judge, if they had a financial interest, would recuse. And if they didn't, as I said, they could be subject to discipline. I would hope that we would make sure that we are complying with all our obligations. I believe, in general, I believe judges are conscientious and are doing and are trying to get these things out. And also, I believe that judges care about not sitting on cases that they're not supposed to sit on.
Okay.
And so I think that they would, I believe that judges are conscientiously trying to do this, but of course there have been some gaps that have been identified.
Okay. Judges are currently notified when requests for copies of their financial disclosures are made, including the identity of the requesting party. Could this have a chilling effect on whether a litigant makes such a request? And without this information, how can a litigant ensure that the judge hearing the case does not have a conflict of interest?
Again, I don't deal with personal financial disclosures. I haven't studied that issue. I would hope not. Judges are, as you pointed out earlier, we have judicial independence, and we should recognize that some people will want to know information about us. I used to run for office in Texas, and people want to know information about judges. People want to know information about federal judges, information that doesn't damage our security or our well-being or those of others or impact third parties' security interest or privacy interest. People are going to want to know, and I don't think the judges should hold that against litigants.
Okay, thank you, Mr. Chairman. I yield back.
Thank you. I now turn to the gentleman from New York, the chairman of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Judge Elrod, thank you for testifying today. I'd like to ask you a similar question to one I posed to the first panel. It seems that many of the difficulties with financial disclosure and recusals could be avoided if judges and their close family members were restricted to holding only mutual or index funds. Would that solve this problem, not only by eliminating the appearance of impropriety, but also making things easier on individual judges who would no longer have to keep track of all their investments before they take on a given case?
Well, Chairman Nadler, I agree with you that holding mutual funds does simplify the process for judges. As we indicate in our guidance to judges, mutual funds can ordinarily be a safe harbor for judges, and they simplify the processes for judges. So do I think that it would solve every problem regarding recusal? Certainly not, because there are broad and mandatory financial recusal provisions that deal not only with stock holdings, but with any financial interest, and then also all of the other types of reasons that judges have to recuse that don't involve finances at all. But it is true that although a judge is permitted to own stock, the recusal statute and the code also discourage judges from having financial interests, stock or otherwise, that might lead to frequent recusals. The codes of conduct state specifically that as soon as the judge can do so without serious financial detriment, the judge should divest investments and other financial interests that might require frequent disqualification. So judges need to be mindful of all of these decisions when they're considering what should be in their portfolios or considering their spouse or their minor children.
Excuse me, I don't understand your answer. If we required that judges have everything in a mutual or index fund, why wouldn't this solve all the problems we're talking about?
It would help with with the financial recusal issues, some of them, except for any other type of financial interest that wouldn't be a stock-based mutual fund interest. Yeah, you could hold real property, other types of interests and things, not everything.
But as far as stocks are concerned, it would be a solution.
Well, I keep my funds in a mutual fund because I find that it's easier to handle as a judge.
Thank you. I've been surprised to learn that some of the guidance provided to judges about how to comply with the Ethics in Government Act is not made publicly available. For example, neither the public nor Congress can see copies of the instructions that judges are given for filling out the financial disclosure forms. This is in contrast to Congress and the executive branch, both of which make their instructions publicly available. Do you know why all judiciary guidance documents for financial disclosures are not made available to the public? And is this something that the Judicial Conference is planning to revisit as part of its response to the Wall Street Journal investigation?
Congressman Nadler, I do not know the answer to that question. I don't work on financial disclosures, and I'm not familiar with the guidance documents and their publicity. I know financial disclosures as a judge who must complete them annually.
Okay, and a common response from the judges who were asked by the Journal about their failures to recuse was they did not know they were required to recuse under the circumstances, either because the investments in question were held by a spouse or were managed by a money manager. Both circumstances that fall squarely within the recusal statute. This seems like a failure in part of training. How does the Judicial Conference plan to redress this going forward?
Congressman Nadler, as I indicated earlier, we have already begun training specifically on these issues. I conducted such training for my circuit judges already this month. We are going to have continued training through the end of the year and beyond, but we're going to be having a significant amount of training on this very issue. We don't want any judge to be ignorant of the rules regarding financial holdings. It's very important because judges are ultimately responsible for their financial holdings.
Thank you very much. I yield back.
Thank you. The gentle lady from North Carolina is again recognized for 5 minutes.
Well, thank you for your generosity, Mr. Chairman. Judge Elrod, I'd like to read from a statement from Ms. Sherry Cheshire, whose husband Jim died of mesothelioma, and whose wrongful death suit was effectively ended by a judge who owned at least $15,000 worth of shares in each of the two defendants in that case. And the judge's financial conflicts were disclosed by the Wall Street Journal. Ms. Cheshire wrote to the chairman, and I quote, "To learn this now, 3 years after our case ended, is like reopening a painful, painful wound. I always knew that no lawsuit would ever bring Jim back, but I did feel that getting justice would, in some way, honor Jim and his service to our country, of which he was always so proud. To now learn that we were never going to get justice because the judge had a financial interest in 2 of the companies responsible for Jim's death is a shock and a devastating disappointment. I thank you for the opportunity to be heard, and I know Jim thanks you too for hearing him," end quote. Ms. Cheshire's statement shows that the effect of a judge's failure to recuse isn't abstract or hypothetical. It's real. The appearance of unfairness causes real pain to the parties who come to our courts seeking justice. What would you say to Ms. Cheshire in response to her written statement?
Congresswoman Ross, I cannot respond about any particular situation regarding any judge and their recusal obligations so I cannot respond in particular. But as I stated in my opening statement, it is crucial for the integrity of the judiciary that we make sure that we comply with our ethical obligations, both to avoid impropriety, but also to avoid the appearance of impropriety. Litigants need to know that they have judges who will fairly hear their cases.
Would the gentlelady yield?
I yield.
Thank you. I just want to ask you, in the kind of a case that was just referred to, where it is demonstrated, assume the facts. It's demonstrated that someone was not treated fairly because of a conflict of interest by the judge. What can be done to right that?
Well, the clerk's offices have written to, and again, I'm not speaking about any particular case, but I know that the judges have instructed the clerk's office to notify the litigants if they participated, and then the litigants may have opportunities to pursue other avenues about the cases. It depends on the individual case. I could not comment on any pending case or any particular outcome, but they could pursue, litigants in general could pursue things to open their case or to pursue different avenues regarding in the court system for their case. But also, as again, I've mentioned earlier, the Judicial Conduct and Disability Act of 1980 provides ways that judges in the Judicial Council of each circuit can deal with judges who don't obey the rules. But again, I'm not talking about any particular or real world situation.
I thank the gentlelady for yielding. I yield back to her.
Mr. Chairman, I yield back.
Thank you. I have one question about the conflict checking software that I understand is built into the case management electronic case files, or CM/ECF system that the courts use for all court business. That system has gone largely unchanged for almost 2 decades. It has been criticized by a range of experts as unfit for the business of the United States courts, and it has proven itself vulnerable to external security risks. Most modern conflicts checking software catches even misspellings and close variations on names, but CM/ECF cannot. I fear that CM/ECF is really not up to the task of screening for financial conflicts. It's supposed to be a fail-safe, a resource of last resort when judges' individual personal conflict checks fail. In response to the journal's reporting of exposure of the widespread failures of that system to operate as intended, does the Judicial Conference or the Administrative Office have any plans to update CM/ECF so that it is better suited to fulfilling its critical role? And if so, can you describe what those plans entail and when the public can expect to see those plans implemented? Judge Elrod.
Chairman Johnson, we have a next gen CM/ECF that also works with our conflict checking software. Our conflict checking software can check misspellings. If it's set for that, it can check miscapitalizations, spaces between words. Our conflicts checking software can work at a very it's at a very high level of checking for those things if it's set for those levels. Now there's a tension between, you don't want to overset automated software that might over recuse based upon similar named parties and things like that. But at the same time, you want to make sure you catch them all. And so one of the things that we are actually working on right now is determining what are the best practices for what the settings should be, and then communicating those throughout the districts in the United States. And I think that's a very important project that can be done fairly swiftly.
So the judges who blamed their failure to recuse on the software, what is your explanation for that?
Chairman Johnson, I'm not here to speak about any particular judge's situation or his or her explanation. I'm here to talk about what I have learned about improvements we can make in the judiciary. And one improvement we can make is that we make sure that every check is done before a case is assigned, and that the software is set so that it does capture misspellings, miswords, capitalization issues, things like that. And so those are things that can be improved and can be improved quickly.
Thank you, Judge Elrod. We appreciate your testimony today and for your patience throughout this hearing. And with that, our hearing is adjourned. Thank you once again to all of the witnesses for appearing today. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned.